compromise that was identified in those proceedings as Phase 5, and Sacramento Valley interest, a large compromise in what was identified as Phase 8. Those were really important because they avoided adversarial proceedings before the State Water Board to do the balancing for those portions of what was before the board in trying to sort out water quality responsibilities down in the Delta. Balancing is really hard to do. That's been addressed in one way or another by a couple of our previous lecturers. In 2014, in the third lecture, Buzz Thompson said, our current system of ecological protections doesn't seem to be working very well for anyone, and suggested, quote, a big thinking new direction, close quote, is less likely to focus on individual species and more likely to look at overall ecological health. Take a broader view in order to make some progress. In the second lecture, the late, great Professor Joe Sachs was talking about the decades of battles over Delta water resources. And Joe said something that I've thought about often ever since that day he spoke here. He urged competing interests to, quote, try some sort of good enough solution. And he invoked Voltaire. The quest for the perfect is the enemy of the good. And he followed that up by invoking Pogo Possum and said, we have met the enemy and he is us. I think about things like that often because I think it's important to not get so bogged down in the fine details of what you are focusing on and think a little bit more broadly. I've gone back and thought about, because I came out of East Bay Mud, how East Bay Mud evolved in ways that involve being able to take that broader look a little bit beyond the fundamentals. When the linchpin of the East Bay Mud system is Pardee Dam. Pardee water rights application was filed in 1924, and believe it or not, the dam and the conveyance facilities were built and water was being supplied in the Bay Area 5 years later. Just not something you can even conceive of today. But there was a downstream interest in the city of Lodi that was in conflict with what East Bay Mud was trying to do, because Lodi had appropriative rights and it was concerned that the manner in which East Bay was going to operate would result in diminution of the water table, reduction in the water table in municipal wells. They sued. It was a very complex piece of litigation. Also involved Lodi suing PG&E, which has a big hydro facility upstream of East Bay Mud, and it was a bunch of complex litigation. It went to the California Supreme Court in 1936, and that's the case where the Supreme Court first started talking about the fact that courts have a duty to seek a physical solution to avoid waste when they're sorting out the competing rights of senior and junior appropriators. East Bay Mud could divert, but they ended up, as a result of what the court said, having to provide a substitute supply if their diversions injured a competing appropriator in a defined way. A very creative solution was crafted, and it satisfied the needs of both of these appropriators in a manner that they could both live with. I think that was a creative solution. The second leg of the East Bay Mud system was the Comanche project, where the water rights application was filed in 1949, and in that case it didn't take 5 years, it took 15. They closed the dam in 1964. A lot of things that pressed in on water rights and water policy and water management since 1929, 1924. And Comanche was being built in an era when you had to build a multi-purpose project, and it was a flood control project as well as being a water supply project, and it was fortunate that they closed the dam in 1964. Otherwise, most people who've looked at it think that the city of Lodi would have been flooded. There were competing appropriative applications at the time East Bay Mud filed its rights for Comanche. East Bay Mud's application was junior to an application filed by an irrigation district on the McKellamne River. But after a long and bitterly contested water rights hearing in 1955, the water rights permit was awarded to East Bay Mud, the junior applicant. And it was done based on that Water Code Section 106 that I talked to you about before. The use priority for domestic use trumped the time priority of the irrigation district's application. The decision, however, paid attention to the fact that there were competing applicants, both of whom had unmet needs. And the decision said that one reason we can do this is that the Congress had authorized the Auburn-Folsom South Canal, and that canal was going to terminate within the boundaries of that irrigation district, so help was on the way. Well, as anybody who's paid attention to the Auburn-Folsom South project can tell you, the canal never got all that close to that district, and that district has suffered ever since. They like to call themselves the orphan district, and I think that's with good reason. However, if you read today's Stockton record, you can see that people are still thinking about that competition, because just last night, the San Joaquin County Board of Supervisors unanimously approved a pilot conjunctive use project in which East Bay Mud is going to put some of its water, some of the water that it has pursuant to those water rights that it was awarded back in 1956. They're going to put some of that water into that groundwater basin in a way that is intended solely for the benefit of that irrigation district. And in return, East Bay Mud is getting the right to take out half as much water as they're going to put in, and all of those entities are ending up as winners. I think that that is a great success story, but my goodness, it took 60 years. That water rights decision in 1956, by the way, was not made by the State Water Resources Control Board. It was made by the duly authorized entity or person at that time to issue appropriative rights. It was the state engineer, and the particular state engineer in question was someone many of you have heard of. It was Harvey Banks. I was going to talk about one other East Bay Mud example. I can talk about 3 or 4, but there's just one I'm going to talk about, and that's one where there was a really creative effort, an innovative idea that failed. In 1988, in a drought emergency, East Bay Mud was concerned about whether it was going to be able to divert the amount of water it hoped to divert out of Pardee, its upper reservoir, because there wasn't going to be enough water in Comanche, its lower reservoir, to satisfy the water rights of downstream interests. And so East Bay Mud, by this time, had signed a contract with the federal government and sought to use that contract to pump some of its Central Valley Project water from a pumping plant down in the Delta, east, up the hill to Comanche, to replace what would otherwise have been McElhenney water that could have been, that might be conserved in Pardee and used for people in the East to drink, in the East Bay to drink. The pump-back scheme resulted in a lengthy hearing before the State Water Resources Control Board, and the East Bay Mud's effort to get a temporary urgency permit was denied. The protestants said they would be injured because there would be a slight change in the quality of the water in their local wells, and because there was a potential for East Bay Mud pumps to ship water hyacinth seeds upstream. East Bay Mud had a really good creative idea, but it failed for 2 reasons. One was they couldn't overcome the fundamental, the no injury rule. And the other is they were in it all by themselves. We didn't have any allies or friends when we were doing that. We didn't build any community support whatsoever. And then the last thing I'll talk about with regard to East Bay is Freeport. The big litigation over the American River began in 1972 when a group of environmentalists sued East Bay Mud. But the horsepower and the money for the litigation against East Bay Mud came from Sacramento County, which is, of course, the parent of the Sacramento County Water Agency. There's a crowning irony in that, because if you go and look at the west wall of the Folsom South Canal, you can do it on Google Maps today, you can see the 5-gate structure that the Bureau of Reclamation built for East Bay Mud to divert the water under its contract. And just up the canal, a very short distance on the same west wall, you can see a 7-gate structure that was built to supply water for the Sacramento County Water Agency under its contract. But Sacramento County was swayed by the loud voices of excellent advocates for recreational and fisheries and in-stream uses in the lower American River, hence the 20 years of balancing. So what happened as a result of that 20 years of balancing? 2 decades of litigation, everybody claimed victory, and then nothing happened. Nothing happened. The water demand of both sides went unmet. And then finally, 10 years later, without any lawyers in the room, I suspect, although I don't know that, there began to be some conversations between the leaders of Sacramento County, and who are also the leaders of the water agency, and at East Bay Mud, who said, we got to do something about this. They came up with a really creative solution. Some of us would say, at some points in our lives, it is a somewhat illogical conclusion, and it is an expensive conclusion, but it works. And now the Freeport project serves the needs of both East Bay Mud and the Sacramento River, the Sacramento County Water Agency. Art tells me I'm running out of time. I'm going to speed this up a little bit and have a couple more things I want to tell you. I view those examples I tried to give you about the East Bay Mud situation as examples of creativity and innovation that generally can result in mutually acceptable solutions for problems that East Bay Mud was dealing with in the relatively small world of East Bay Mud and its McKelvey system. Last year the lecturer was Pat Mulroy, and she talked about the model of the Colorado River. And if you just think about it, there are some striking similarities. You go back to the 1922 compact between the 7 states, and if you think about it, 7 states, 7 legislatures, 7 governors, approved by the Congress, signed by the president. Everybody's in. They started off by saying, we've got something in common here. They reached an agreement that got away from the principles of first in time, first in right. They formed what Pat described as an equal partnership. And here's how she said it. Every one of us has an equal right to a future. Every one of us has equal right to the waters that we share. We set aside first in time, first in right, because in the interest of all, we're going to share this system. And she had a formula for it. You get the right people in the room. You get everybody to acknowledge that everybody else has a recognizable interest. You get everybody to acknowledge that there are more claims and demands than there is water. And you stay with it long enough so that essentially each person at the table can make all the arguments that anybody else at the table is going to make. And you build a compromise solution that recognizes that the security and reliability of each of the competitors can only be completely satisfied if all of the competitors' interests are going to be satisfied. The Colorado is different than anything else that we do. I mean, you started with 7 states, and that's a huge fact. But we're seeing lots of examples in California now where these principles, I think, are at work. You see integrated water resources management planning going on that in many cases is proving to be very fruitful. Right here in the Sacramento area, at the Water Forum, you have the Water Authority, you have the Groundwater Authority, you have Freeport that I just talked about. A little ways west of here, you have the Woodland Davis Clean Water Agency, and that's a compromise organization that was a long time in coming and it makes all kinds of sense. A little northeast of here, you've got the Yuba Accord, which is a wonderful model for how creativity and innovation can work within a complex system and provide multiple benefits, in that case, really statewide. In the Bay Area, there's a very promising amount of activity going into the Regional Reliability Program where Bay Area and water entities are working together to see what they can do among themselves that will help everybody get better together. I mentioned the East San Joaquin Groundwater pilot program, and as I say, that was to address the disappointing outcome in some respects of Decision 858 back in 1956. There are probably dozens more. But you know, as Californians, I always like to stop and think a little bit about certain things that are our hallmarks. And we have one quintessential thing that happens every year in California, and that's the Rose Bowl. And if you ever listen to the sports announcers on NBC or whatever network has it now, they always say, the granddaddy of them all. To me, the granddaddy of them all, right now, in California, in terms of collective, cooperative efforts, et cetera, is just getting started. And that's SGMA, the Sustainable Groundwater Management Act. And I'll talk a little bit more about that a little later. Let me leap ahead to the concluding statements I want to make, and I'm going to skip through the many words I have written here. Challenging and competitive subject. As I said before, you got to start by understanding your facts. You got to start by understanding your fundamentals. You need to go into any problem with a clear realization of the breadth and the nature of the individual interests that are at stake. And striking an appropriate balance is far more complicated now than it was before we entered the reasonable use era. There are always going to be multiple parties or interests. Each of them are worthy of recognition and acknowledgement if the decisions we're going to reach are going to be, as Ann would say, fair-minded and truly comprehensive. The people who are the advocates for the various interests that are at play in any complicated policy or allocation circumstance, they don't generally start out as friends, and they may not end up as friends. But they can only reach those fair-minded and truly comprehensive decisions that Ann talked to us about if along the way they develop mutual respect, and most importantly, they have to learn to trust the other participants. And that idea of learning respect and trust, even though the people you're dealing with are not your friends, that can sometimes be the hardest thing of all. Balancing hard to do, and balancing is particularly hard to do well. Ann taught us, as Judge Roby said, that we need to be prepared to guide our clients away from the hard line, to consider the broader public interest in addition to our own private interests. That statement to me represents the new paradigm Ann challenged us to seek. I want to end where I began by talking about Ann. And I need to give credit for this thought to Felicia Marcus, who will be up here on the stage in just a couple of minutes. You know, one of the things that we all hear about almost every day here in California now in the water world is the governor's Twin Tunnels proposal. And no matter what comes of it, whether it is a part of his legacy as governor or not, I think that SGMA, the Sustainable Groundwater Management Act, which we'll talk about a little bit more when Felicia is here, to me it embodies sort of the epitome of local consensus and cooperation, and most importantly, communication. And there's a direct historical line between the SGMA Act that we're learning to live with today and that 1978 groundwater paper that Ann wrote when she was on Hap Dunning's staff at the Governor's Commission to Revise California Water Law. That's all I have to say. I hope I haven't put anybody to sleep, and I look forward to a conversation with Felicia and to your questions. Thank you.
I'll just do a very brief introduction. As we've started about four years ago now, we have a conversation between the speaker and another person from the water world. And this year, we're joined by the chair of the State Water Board, Felicia Marcus. I think most everyone knows Felicia here. She was appointed in 2012 and became chair in 2013 by Governor Brown. She's worked all over NRDC as a Western Regional Director for Trust for Public Lands, 8 years when Felicia and I met. You were working for President Clinton, Region 9 Administrator, dealing with stormwater and some mellow issues like that, water quality issues. But she also worked on tribal issues, Pacific Islands, California, Arizona, Nevada. And also, one thing I didn't realize, Toy, that you were one of the founders of Heal the Bay, and its first general counsel. So, worked for LA Department of Public Works. So, take it away.
Thank you, Art, very much. Appreciate it. And thank you, Bob. I'm glad I get the chance to talk with you in front of all these people.
It's very, very nerve-wracking, Felicia. Our one-on-one conversations have caused less stomach churn, let's put it that way.
Well, it was funny, this morning I was thinking about all the things I had a lot of gratitude for, which is always a good way to start the day. I recommend it to anyone who hasn't tried it. It can change the way you look at your whole day. But I was walking in the rain to my car, and so of course I had a lot of gratitude for the rain and the snow, not just today, but this whole season. I was grateful we were out of the drought for the moment, but still actively preparing for the next one and the next one. And I found myself being immensely grateful that we're blessed by having Bob Maddow in our midst in general, just as a matter of principle. And in the water law world in particular. He's a talented lawyer, but also an unusual mixture of wisdom and humility, of intellectual curiosity and humanity. He's a keen observer of the law, of the practical workings of water system. As a former public works director, I always respect that quite a bit, and of people. And he's a brilliant storyteller, but also is an avid listener and an observer both of what is said and what is not said. And I suspect there are quite a few people in this audience that view him as a mentor, which is another thing to be grateful for. You are as empowering as they get, and that is not an easy thing to do, and very few people do that. I also really appreciate something I did not know before today. I didn't know it until Art introduced you and flashed that picture, and that is you are an expert predator suppressor. I felt very grateful for, and I know a lot of the people in this room do too. So I'm honored to have the opportunity to start this one off by asking some questions, so we'll get to it. First, I wanted to ask you a little bit about the profession itself, because this gathering is a gathering of the community of water lawyers which meets a lot of the time, certainly in the Aqua Legal Committee, which is where I first met you. But this is a particularly people-centric, infused with Anne's spirit and that combination of intellect and grace that you share with her. So I thought I'd ask you a question or two about the profession and where it's been. And you're known as I said, as a thoughtful and observant human, what my grandfather would call a mensch. So I don't want to miss the opportunity to ask you. So I'd like folks, I think folks would like to know how you actually seen the water rights profession itself evolve over the past 30 years. And has it evolved? And if so, what strikes you most about it? And what kind of progress, hopefully, have you seen?
There are two things that strike me about the evolution that I've witnessed. One is that I don't consider myself to have been a water rights lawyer. I've always been more of a general counsel type who did a lot of work in the water field. But I always viewed the water rights practitioners as being a pretty small and really excellent, like a fraternity, and it truly was a fraternity when I started, because until Anne came along, and I also remember Ann Thomas from Southern California, there were not a whole lot of women in the field. And the two changes, I guess, that I would note are these. I think that the fraternity, if you will, of lawyers who are dealing with water rights has grown, and that is in part because of all these additional pressures that are now coming to bear on water policy, water rights, water allocation matters. And so you're seeing people who come from a background that is broader just than having steeped themselves in all the old water law cases and having memorized Wells Hutchins' treatise and things like that. And I think that has been valuable because the world they're working in has changed, and I think that evolution, if you will, has been a refreshing evolution to the profession. I am particularly pleased, though, to see that the trail that Anne blazed is being followed. A couple of years ago, maybe it's 5 or 6 years ago now, I was talking to someone about this, it suddenly occurred to me that as I looked around the California water community, you know, a big part of my career was serving as an in-house lawyer for a water utility. And I looked around the state for water utilities I was familiar with, which had in-house counsel. And I found a whole bunch of them where the in-house counsel were women. East Bay Mud, where I had come from, Marin Municipal Water District, the San Francisco Public Utilities Commission, Santa Clara Valley Water District, Metropolitan Water District of Southern California, Zone 7 in Alameda County, and there were others. And I thought to myself, wow, you know, 30 years ago, when I had started, unheard of. I think that's a wonderful form of progress. And I think it's progress not just because of gender balance, which I consider to be extremely important, but I think it's progress because men and women do come from slightly different planets, and they bring slightly different analytical and thought processes to bear. And when they are both steeped, men and women are steeped in the same facts and fundamentals and that sort of thing, they don't necessarily all get to the same place. You know, get there through slightly different paths, and the whole is much greater than the sum of the parts. And I think that's been a valuable change.
Well, I like that answer. Here, and this could be a trick question because it's perilous in terms of your answer, and I will put the caveat on it before you even need to, which is, of an enormous list of people you admire, I am sure many of whom are in this room, who do you admire most in this room?
Well, of course it's you. Well, let me start with water lawyers, and I thought about this before. Felicia and I have talked several times, and she mentioned to me that she might throw me a question sort of like this. And 3 of the water lawyers I think a lot about in response to that question are the 3 A's: Anne, Adolph Moskowitz, and Art Littleworth. All greats, in my opinion, in different ways and in slightly different times and that sort of thing, and I could go on about each one. But each was just a superstar, in my opinion. Another one of my sort of heroes is Joe Sachs. I got to know him just a little bit when he was at Berkeley and I was at East Bay Med, and he invited me up to give lectures a time or two. I got to know him a little bit more when he and I both served on a committee working on some issues down in the Coachella Valley. And I found him to be a thoroughly interesting guy who, gosh knows, was a master of water law and water rights and that sort of thing. But that wasn't by any means the only thing of which he was a master. And that sort of Renaissance man quality about him made him an ever so much better water lawyer and professor. And I think that is really important. And I'll mention a couple of other names, and this is by no means exclusive, but in sort of more contemporary times, I was going to mention the names of a couple of people whom I have really come to admire because of their ability to identify the critical issues in a complex problem and then apply that knowledge and a complete understanding of not only those issues, but all the interests in those issues to come up with a creative solution. And the two names I'll mention are Richard Roos-Collins, who's here in the front row, embarrassingly holding a video camera. and Paul Markowitz, and I say that in particular for Paul.
Because he's a Red Sox fan?
Because, well, of course, no Sox, but also because I think that the Yuba Accord is a singular achievement, and although I know there were certainly a number of participants in making